Just before the short adjournment, we were about to leave the vanished world of capability determinations. And the point to just recap on is, of course, that the sort of exercise that Lord Justice Salmon envisaged in Slim will disappear from view, because it won't be the case going forward. Now that we have early meaning determinations, there will be no situation in which the Court of Appeal will have to consider the range of available meanings in deciding whether or not they should interfere with the judge's decision.
Sorry, just for my benefit.
Yes.
Why might there not be a possibility of appeal from the early determination?
It's possible that they might, but it would be surprising, because at the early determination of meaning, you're going straight from any consideration of available meanings to determining the right meaning. So capability, which was so important.
I see, of course, capability.
Yes, capability in the old days was very important, because that set the parameters for what the jury could pick from.
Of course.
Or potentially a judge, if, as sometimes happened, a case was ultimately not
we won't see a concrete capability assessment in the court below to get our teeth into.
Precisely right.
But the question I was asking this morning was, is there an analogy with some levels of appellate scrutiny where you ask, is the judge's conclusion, say it's a multifactorial assessment, outside the range of reasonable conclusions which a judge could reach in the context?
Well, that's, as you jump rather preempted what I'm going to say, is that there is an analogy to be drawn with capability. And I hope to distill the test that we say should apply from what Lord Justice Bukowski had to say. But the preface to that comment is that we say there remains a compelling case, even now, for the courts to remain cautious, or whatever phrase one uses, proceed cautiously is the phrase used by Lord Justice Simon in Bukowski, or not interfere lightly, to hark back to the language of Lord Justice Salmon in Slim. But either way, to proceed cautiously before overturning a first instance judge's finding of meaning. Firstly, and I'm grateful to my friend for reviewing the authorities, but the authorities that were reviewed by Lord Justice Simon in Bukowski, from paragraph 30 onwards of the judgment, and if you the reference for that, if required, is page 353 of the bundle. I think, my friend, it's fair to say that there was something of a potential for confusion to have been sown by the various different formulations adopted by the Court of Appeal in those various cases. And you'll recall phrases like satisfied, quite satisfied, or clear that some other meaning applies. Now, if one then turns to the, and again, I'm not going to reiterate them because my friend dealt with them, the two options that Lord Justice Simon was weighing in the balance. I'm sorry, I gave, I think, a bad reference to the paragraph 30. It should have been 361 of the electric bundle. Turning then to the distillation of the options that starts, I would say, usefully at paragraph 38. When one looks at the conclusion that Lord Justice Simon arrives at in paragraph 39, the Court of Appeal, that's at page 363, the Court of Appeal effectively rejected option A, which is effectively the de novo approach for which my learned friend contends, namely that the Court of Appeal is as well placed as the judge to determine meaning and should simply substitute its own view if it disagrees with the judge. It also rejected option B, and thereby the, quotes, only when quite satisfied test. And instead, it went for an approach that Lord Justice Simon said was somewhere between the two, but on closer analysis, we would contend is perhaps closer to option B, in that the Court of Appeal is now required to proceed cautiously before substituting its own view, and only doing so when satisfied the judge was wrong. So satisfied appears to be the elected simple phrase without further qualifiers. But then
is the intellectual exercise involved in deciding that the judge was wrong?
Yes.
What does the court say to itself?
Well, it says these. I was just coming to the two qualifications. Firstly, one has to show some caution. Firstly, because meaning is a matter of impression, on which, as we've already seen, even different judges can reasonably hold different opinions. And secondly, having that consideration in mind, it's undesirable as a matter of practice. And this comes onto the policy considerations.
And I'm sorry, that doesn't address the question that I'm asking you. what's the intellectual exercise involved in deciding whether the judge is wrong? Those are features of the performance of the exercise, excuse me, that you be cautious and that you don't embark on it lightly or whatever. But does the court say to itself, the first step in deciding whether the judge was wrong is deciding what I think is the right answer?
Well, ideally, perhaps that's true, but an appellate judge is not in the position of a judge at first instance, because the appellate judge has to consider the arguments put by the parties for the case to be on appeal in the first place. But let us suppose that the ideal scenario would be the judge in the court, the appellate judges look at the publication in their own right and form a view about what the words mean to them, being put in the position of the hypothetical reasonable reader. They then go on to consider the meaning found by the judge, firstly, and secondly, the way in which the judge approached the exercise and the reasons he gave. One of the criticisms often made of judges is they're over-elaborate in their analysis, but as Lady Justice Sharp said in the Court of Appeal, well, the moment the judge gives any reasons for his determination, he can be accused of being over-elaborate.
Yeah.
So the first limb would be to draw your own conclusion, look at what the judge's conclusion was. Thirdly, check the way in which he approached the exercise, in case there might be, as we've seen in some instances, there might be a criticism of the legal approach, that he overemphasised, he failed to apply one or other of the Jones principles. And then at that stage, the appellate court has to say, well, I've got the judge's meaning, and I've got my meaning. Firstly, I need to make allowance for the fact that it's a matter of impression. I can't simply proceed on the basis that I have come, as the appellate court might have done, to a different view. Can I nonetheless say that I'm satisfied that the judge was wrong after making allowance for the fact that there are reasonably different views that can be formed as a matter of impression? So that would seem to be the ideal way to approach the exercise. The Court of Appeal...
The appellate judge says, well, this is what I think is the proper meaning. Now, I can see that someone else, such as a trial judge, could have taken a different view, but I cleave to my own conception of what is the right meaning. Apart from a general enjoinder to be cautious, is there anything else which should inhibit him from saying the judge was wrong?
Well, I think the way perhaps if I could presumptuously put myself in the imagination of an appellate judge, not that I have any experience of that, is to say, okay, the judge found meaning A, I've read the words, I think it's meaning B. So the first observation is I disagree with the judge's conclusion. The next question is, well, given that this is a matter of impression, is my meaning and his meaning or her meaning meanings that are within the bounds of what is within the bounds of reasonable difference? And if the answer to that question is yes, then that would presumably be the end of the exercise.
The bounds of reasonable difference.
Yes.
And that sounds rather like the approach that one would take to ordinary questions of fact.
Yes.
I mean, either you can, obviously you intervene if you can identify some error in approach by the fact finder. Equally, you would intervene if you take the view that that the finding is one that wasn't reasonably available to him.
Yes. But I mean, this is the difficulty here is that the nature of the single meaning rule is one can still make a finding that the judge was wrong while accepting that, or potentially accepting that it was a meaning that was within the capable range and was thus open to him. But it doesn't follow because the judge picked a different meaning that he was, of necessity, unreasonable in doing so. That's why you need to have these two checks that Lord Justice Simon identifies.
So long as it comes within the bounds of reasonable difference.
Yes.
It's, by definition, you say, right.
Well, it would seem to be.
Or not wrong.
Not wrong, which is, at the end of the day, this is an appeal, because there's two other checks. I need to remind myself, says the appellate judge, firstly, is this within the bounds where different views are reasonably possible? And secondly, I need to exercise caution because I mustn't proceed on the option A basis that, well, I've disagreed with the judge and therefore that's enough to overturn it. So we say that formulation of Lord Justice Simon provides the check. And in fact, I would distill the test, we would distill the test as follows. Is the appellate court, after proceeding cautiously and making due allowance for the fact that meaning is a matter of impression on which views may reasonably differ, nonetheless satisfied that the judge's meaning is wrong? Suggest that that is a workable test that distills the two elements of checking that that Lord Justice Simon had in mind, and proceeding cautiously also embraces the fact that it's undesirable as a matter of appellate policy for the court simply to substitute an opinion because it disagrees with the judge. And we say
Can I just ask you about,
yes,
on which views may reasonably differ?
yes.
Is what Lady Justice Sharp says at her paragraph 19 about within the range of meanings open to him, the same way of, a different way of putting the same
Well, one
thing?
hesitates to say that, but all these reformulations often amount to much the same thing. So,
But we get back to the capability question again.
yes, it's perhaps best to move away from capability, because capability was in itself a construct to decide what meanings were left to the jury. But there is an element of similarity with it. I think my Lord Briggs was saying, can there not be said to be an analogy between the old capability determination and the assessment of what's within the parameters of reasonable differences of opinion when considering an exercise that is ultimately a matter of impression? So I would concede that there is a similarity. My friend says, well, there's a flavour of a throwback to the old capability days in the language used by Lady Justice Sharp. But it reflects no more than the fact that the test is not one of simply option A. We come to a different meaning and substitute it if we disagree with the judge. One can use all kinds of phrases, a margin of appreciation for the judge. But we say that the formula that Lord Justice Simon came up with, as we've sought to distill, lays the foundation for a standard of appellate review that firstly preserves the need for appellate oversight, but without undermining the jurisprudential compromise that underpins the rationale and thus the fairness and workability of the single meaning rule itself. The reason why that test is preferable to the carte blanche option A, which would be just the Court of Appeal takes a view, and if it disagrees with the judge, it substitutes its own meaning. Firstly, it would no longer be the fair and workable method. It undermines the single meaning rule. Lord Justice Diplock in Slim referred to it as a fair and workable method. And that was endorsed by Lord Nichols in the Privy Council case of Bonwick, which we've cited from in paragraph 5 of our case, which is at page 77 of the bundle. If it becomes a de novo hearing with the appeal court just has another crack at the issue of meaning, there is a danger of the single meaning rule being undermined and becoming a numbers game dependent on the luck of the judicial draw as you rise up the appellate ladder. There's a second vice, and that is that an increase in meaning appeals that are effectively de novo hearings, quite apart from clogging up judicial resources, which touches on the public policy points my Lord Reid adverted to before the short adjournment. If these appeals could simply be brought as of right, because everyone should have the right to challenge the first instance meaning, that would tend to reinforce the luck of the draw impression by virtue of increasing the scope for majority decisions. Now, can I take the Waterson case, which is at, we've looked at already. I hope not to go there, because my learned friend has already been. That's at tab 27 of the authorities bundle, and the electronic tab reference where the case starts is 687. Now, you'll recall that in that case, Lord Justice Richards was in the minority, and Lord Justice Laws and McComb were in the majority. And Lord Justice Richards said at paragraph 48 that he shared Mr. Justice Tugendhat's conclusion at first instance as to how the hypothetical reasonable reader would understand the words in issue. Now, you'll recall that at paragraph 51, Lord Justice McComb had found that Mr. Justice Tugendhat, he felt, had not paid sufficient regard to Jane's Principle 2, which is the one where you don't select a bad meaning where other non-defamatory or lesser meanings are available, and Jane's Principle 3, which is the over-elaborate analysis. Again, there's a latent danger for the court that if it's going to disagree with the judge's finding on meaning, it doesn't retrofit criticisms under Jane's to justify that conclusion. That is a danger we would suggest also needs to be borne in mind. But having majority rulings on meaning, though sometimes they may be unavoidable, would be an undesirable development if it became the norm, because it potentially accentuates the artificiality of the right meaning rule to the point of bringing it into disrepute. For instance, a jaded observer might observe that the result in Waterson represented something of a 2-2 score draw. You had Mr. Justice Tugendhat and Lord Justice Richards on one side, and Lord Justice Laws and Lord Justice McComb on the other. And the outcome is only ultimately decided by what I might perhaps impertinently call seniority distribution, which is perhaps the judicial equivalent of a penalty shootout. But it does illustrate that once you start undermining the single meaning rule, the compromise that lies at the heart of it, because everyone on the appellate ladder gets to simply act as the trial judge and pick a meaning, the whole compromise that lies at the heart of the artifice begins to break down. And that's why we say, by contrast, having the test, the proceed with caution test that Lord Justice Simon advocates in Bukowski, provides those two tiers of protection. Firstly, not clogging up the courts with lots of de novo hearings, rather like the old days under the old rules of the Supreme Court, where everyone had a sort of dry run in front of the master and then was free to go back to the judge and just try all over again. Well, those days are happily behind us, not least on grounds of cost and use of judicial resources. But the test that we say Lord Justice Simon envisages does provide that element of caution and provides those two elements of pausing for thought by the Court of Appeal if it does decide that its meaning is different to the judge's. Firstly, matter of impression, can views reasonably differ, and the need to remember that it's not an exercise where the Court of Appeal just substitutes its view on meaning without more if it disagrees with the judge.
And I suppose it might be said against you, but in this particular rather unusual context, since the de novo exercise is meant to be a short, simple one that doesn't lend itself to complication and doesn't get much beyond impression, that could be quicker than actually going carefully through the judge's reasoning and seeing if he's taken a wrong turning.
Well, I suppose it could be, but then that, with respect, would fatally destroy the compromise at the heart of the single meaning rule. And therefore, one wonders, well, my learned friend rightly said he wasn't challenging the single meaning rule. It's been accepted as the least worst of compromises. But if it means that it is now a casino where one takes one's chances with who one gets, I mean, I'm sorry to be facetious about it, but that's what it would boil down to. If it is just a de novo hearing, and it's just the luck of the draw, how the judges stack up on firstly, the Court of Appeal, and if one goes for gold and ends up before this court where one has a panel of 5 judges, and that really does, in my respectful submission, kill off the compromise element which lies at the heart of the single meaning rule. There has to be some element of deference, not sacrosanct deference, to the trial judge, because he is the one, or the judge who decides, not the trial judge anymore, the judge who decides meaning at an early stage of the case.
I just wonder whether one should be so pessimistic about casino.
Well,
in any appellate court which decides that a judge was wrong is going to have to explain why they reached that conclusion.
well, if it were
I don't
option
think
A,
it's a question of lottery. You just happen to get the luck of the draw, and it's digestive jurisprudence all over again.
well, I'm not saying it would be unprincipled in the sense the Court of Appeal would just pick a meaning and not give reasons, but if it simply is option A, which is that if it disagrees with the judge, the jurisprudential underpinning for overturning the judge is simply they disagree with him. That is a radical departure from the normal standard applied on appellate reviews. There is always some margin given to the judge. Obviously, it's stronger when he's made evaluations of evidence and seen witnesses. But even on findings of fact, it's never, certainly my understanding, been a free-for-all that the Court of Appeal just starts all over again. Of course, it will give reasons, but it's not simply an untrammeled free-for-all where everyone gets the right to have another crack in the Court of Appeal if they don't get the right result in front of the judge. I'm not arguing, of course, that there should never be appeals against meaning, simply that they should be subject to the cautious caveats that are introduced by the Simon test, if I can call it that, or the Bukowski test. One only has to test it's in the spirit of the compromise of the rule itself to have those qualifications. One only has to consider the alternative tests that my learned friend has put forward to see why the Bukowski test is preferable. Now, my learned friend contends in his case, that's between paragraphs 48 and 50, which starts at page 59 of the electronic bundle, that the Court of Appeal should only substitute its own meaning where that is less serious than that found by the judge. Now, the point we've made in our case is that such a fetter, for which my learned friends provide no juridical justification, would seem to preclude the Court of Appeal from concluding that the right meaning might have been a more serious one than that found by the judge. One might have the case of a disgruntled claimant who says, well, I think the judge has let them off the hook. And the meaning he's found is far too lenient. And my learned friends, for no justification is given as to why claimants should be shut out or why that test should be applied. And we say an unwarranted constraint of that kind would again undermine the notion of the hypothetical reasonable reader. And that lies at the very heart of the compromise we say is innate in the single meaning rule. Now, my learned friends, doubtless because they wish to head off floodgate concerns if meaning appeals were to become de novo hearings as of right, they propose in paragraph 48 of their case that permission to appeal should only be granted where there is a real prospect that such an outcome is likely to impact materially on the claim. But the point we've made is that, firstly, the potential impact of a meaning ruling on the future of any claim, whether in relation to damages or the prospects for a potential defence of truth or honest opinion, is a consideration which is wholly unconnected with the discrete issue of whether or not the meaning found by the judge is right or wrong. And as my Lord Kerr said before the short adjournment, well, the meaning is the meaning, and that's the end of it. What the consequences are for the defendant in pleading substantive defences is neither here nor there. But again, if you start introducing extraneous considerations into the exercise, this only serves to render the single meaning rule compromise unfair and unworkable by virtue of introducing matters which are self-evidently wholly extraneous to the issue of the meaning. The phrase we used in the case, I think, was to put the impact cart before the meaning horse. So I think that's all unless I can assist further, that's all I need to say about the appellate standard of review. We say that the Bukowski distillation, if I can call it that, provides a workable compromise that is in keeping with the compromise innate in the single meaning rule itself, and contains those two checks and balances so that it doesn't become a free-for-all and the judges don't simply substitute their meaning for the one at first instance. Can I turn to the subject of the dictionary definitions? We've dealt with this in the case. I have only a few additional observations to make in relation to the analogies that might be drawn with determination of meaning in other contexts. Firstly, the construction of a contract or similar is par excellence a lawyerly judicial exercise in determining the true single interpretation of words used as a matter of legal art. Now, we say that is very different to the fact-finding tribunal, which, let us not forget, in days gone by would have comprised a lay jury, envisaging the position of a hypothetical reasonable reader for the purpose of determining a natural and ordinary meaning. A hypothetical reasonable reader is not a lawyer constrained by established juridical canons governing the construction of legal documents. And that is another reason why it is quite wrong for my learned friend to seek to introduce evidence of statutory provisions repealed 50 years ago, authorities interpreting 50-year-old deceased statutory provisions or CPS guidance, because that simply has no bearing whatever on the natural and ordinary meaning of the hypothetical reasonable reader who would know nothing of such things. It's interesting to, your lordships, my lady may not have had a chance to, or had occasion to look at the first instance judgment in Bukowski, which is happily in the first volume of Authorities at tab 9, or page 346. But you'll recall there that the facts of the case is that the claimant was protesting about a CPS press release that referred to the fact he was being charged in relation to an offence of making a photograph of indecent images of children. Now, of course, making a photograph was the statutory definition. And what the claimant sought to argue is, well, by saying making a photograph, the layman would understand that to mean that I was actually present when the photographs were taken. And that's a far more serious imputation than simply being somebody who has been provided with or just has downloaded child pornography or images of children on his computer. And it's interesting, if I can ask your lordships, my lady, to look at page 351 of the bundle, which is paragraph 19 of Mr. Justice Walby's judgment at first instance. This observation was made by the judge. As Mr. Callis, who was appearing for the claimant, points out, these are points of law. In a defamation action, meaning is a question of fact. The natural and ordinary meaning of words issued to the public at large in a press release is not determined by the meaning which the law may attach to those words as a matter of statutory construction. Mr. Callis submits the very same words can and will have different meanings as a matter of fact, and they do, in a particular context, to those who are legally trained as a matter of law. It is certainly true, says the judge, that in principle the same words could have a meaning for the purposes of defamation law, which is different from their technical legal meaning. Whether these words do have a different meaning is a question for me to decide. But it's of no value, we say, to go back and look at what lawyers might understand the words tried to strangle to mean, whether it be back under the Offences Against the Persons Act, in an authority dating back from 1962, I believe, or in the CPS guidance, because those matters would not be matters of common knowledge to the hypothetical reasonable reader.
Would the dictionary definition be?
Well, dictionary definition, again, I don't want to tread over the ground. Dictionary definitions have long been recognised as a useful check as part of taking judicial notice. You'll have seen in our case, there are lots of examples of defamation cases where either counsel have tossed around definitions, indeed we've cited a few examples, or where the judge has produced a definition as a check. Now, the criticism my learned friend makes, and made again this morning, is that the judge in this case effectively used the dictionary definition as a crutch and stopped his analysis there. He just adopted the OED definition.
Well, he started off with the dictionary definition, didn't he?
Well, again, he raised it. I was actually going to take your lordships to the way the matter evolved in argument very briefly, because it was really only used as something to weigh in the pot. And if I can ask you to stay in the main bundle if you're using the paper one, or otherwise turn to page 163 of the bundle. This is from day one. This is the argument in the trial. I'm not going to read it all out. If one can, perhaps the court, once retired, the court can consider this in more detail. But it's interesting to see how the judge introduces at page 163. There's the discussion at the top of the page of page 9 of the internal pagination at the top. Mr. Justice Bidding says, "Can I suggest that both of you look at the OED definitions?" And then what we say is telling is what he says on page 10 of the internal pagination of the transcript, at the bottom left-hand corner at line 10. He says there are two possible meanings here. Both of them appear in the dictionary, and then we say these important words. The colour of them, however, in the message has to be taken from the whole message, and the use of the word tried is put in. So it's simply not right to say that the judge just latched on to the dictionary definition meaning and cleave to that throughout. He uses it as a check, but then from the very outset says that, well, that one has to see how that is all coloured by the way the the words are used in the context of the message as a whole, which again we say gives lie to the suggestion that the judge didn't have regard to context. Indeed, he was alive to context throughout.
If one goes to the judgment itself,
Yes.
he appears to pick this up at paragraph 36, which is at page 137 of the bundle. And it's true that he does say one can turn to the dictionary to confirm the meaning in ordinary usage of a single English word.
Yes.
But this does appear to be the heart of his reasoning in support of the conclusion to which he came. There's nothing here about context or the nature of Facebook pages and so forth, is there?
Well, that comes, of course, that comes as well. And if I can use as a shortcut, if I can ask you to look at paragraph 40 of our case, I'll give you the reference in a moment. That's where we set out.
Can I have a page?
Yes, it's page 92 of the
Thank you.
electronic bundle.
Yeah.
And it's just to answer my Lord Kitchen's question. And this is where we say there's nothing in the castigation from the claimant appellant, for the judge having said nothing about context. And here we set out in the bullet points all the different places in the judgment where the judge does indeed sort of at some length expatiate on the context of publication. I'm just going through them, that the drip feed of postings unfolded over the period of some 2 hours and 18 minutes. And you may have picked up that there were the second bullet, that A had made the try to strangle me allegation not once but twice during the Facebook exchanges. And if one looks at the words complained of, which you have, I don't propose to go there, but there is a gap of some 49 minutes between the first instance and the second. So that's something on context the judge picks up. You then have the observations about trying to strangle in circumstances where she was alive and the police had found handprints on her neck, and so forth.
Did the judge get a reasonable explanation of how Facebook worked? I think he said at some stage he would
Well, there was no expert explanation. Yes, I mean
I don't mean from an expert.
Yes, I mean
There are probably any number of people in court
anecdotal
who could have told
explanation
him.
from counsel, but not detailed. Yes, about the fact there's a wall, and that it's. But yeah, the judge, I mean, does advert to the fact that the fact he was aware and alive to the fact. If one turns to page 246, you've got the words. You may not have had occasion to look at this, but this is the transcription of the postings and the times they were made. So 246, you have that's where the judge gets in the judgment the reference to 2 hours and 18 minutes. You'll see the first flurry of exchanges at 12:16 in the afternoon. And
I'm sorry, you've lost me.
I'm so sorry, it's page 246 of the electronic bundle.
Is this something the judge had?
Yes, it is, yes.
Right.
Oh, I see, thank you.
Yes. And if I can ask you to turn over the page, you'll see that the first reference to trying to strangle is at 12:49 at the top of page 247. And then there are further exchanges. And then if you go to page 248, you'll see, so that's at 12:49. At 13:27, Ms. Bly asks, why did Terry get arrested? She then replies, the appellant replies a minute later, clearly I don't like him very much, that's why I divorced him. 7 minutes later, Ms. Bly again asks the question, why has he been arrested? And then he gets the response, well, you know about him trying to strangle me. Well, yes, she does, because she told him, she raised this point 49 minutes earlier. Then he was removed from the house following a number of threats he made and some gun issues, I believe. And then the police felt he had broken the terms of the non-molestation order. And when one comes to the judgment and context, the judge very much had in mind, it was the concatenation of trying to strangle me twice, and then the second time for good measure with references to gun issues and being removed from the house.
It was two references to the single incident of strangulation.
Yes, these are two references. There's only one incident of strangulation.
Yes,
Yes,
indeed.
that's right. And the judge alerted the fact that, in order to dispel the idea that it was akin to a slander action, it was a throwaway comment, or he tried to strangle me. Firstly, it was said twice, not once. And the second time, it was rammed home with cross-references to gun issues and being removed from the house by the police. Now, that fed into the dangerousness sting, which the judge found to be an important part of the meaning. A point I've already made before the short adjournment, the very meaning that my learned friend sought to justify, the general sting of dangerousness. and which characterised the judge's findings in relation to justification, because he said, well, in relation, there's a gulf, and I'll come on to that when I deal with justification. There is a gulf between what the defendant was putting forward as a case, that is to say, a violent gripping of the throat, such as to put the appellant in fear of her life, to what the judge actually found, which was simply that he put his hand on her mouth, the other hand on her neck to keep her quiet, committing something that was a common assault and unattractive, but not nonetheless a world away. A different order of magnitude was the phrase the judge used from what was put forward by the appellant in her pleaded case. And as we know in the evidence she gave at trial, she reintroduced the accusation she made to the police at the time, which was that as the incident supposedly took place, the respondent said, I'm going to kill you. Now, the judge made findings that fell well short of that, which is why we say, in relation to that element, that the plea of justification was always doomed to fail, even on my learned friend's own meaning, because, of course, his meaning was to the violent gripping of the throat to put the respondent in fear of death, whereas the judge's finding was something considerably falling short of that.
Well, they were sufficiently, she was sufficiently strongly gripped around the neck to leave marks which were demonstrably there till 2 or more hours later.
Well, I certainly don't want to trivialise it as an incident of domestic abuse, which is the finding the judge made, unpleasant domestic abuse. But it's not something akin to an attempted murder or an attempted GBH, which is the case that the defendant was seeking to make.
But one might think it would be not unreasonable for somebody who has hands put around their neck with such force that it leaves marks of that kind, that they may fear that they are going to be asphyxiated.
Well, the difficulty there is in terms of the findings, the judge didn't accept that evidence. And that's something my learned friend is stuck with, because the evidence was given. Not only did he grip his full weight was on top of me. And again, this is all in the case,
Yeah.
but we've summarised the evidence. The evidence was his full weight was on top of me. He had his hands violently gripped around my throat. I thought this was it. And her evidence that emerged in cross-examination for the first time was, and as he was doing it, he said, I'm going to kill you. And that's a very different, and I accept, I'm not seeking to justify the respondent's conduct, but it is, as the judge said, of a different order of magnitude, or as the Court of Appeal said, endorsing that, a material difference in gravity. That's in paragraph 25 of the Court of Appeal judgment at page 107 of the bundle, which we've cited in paragraph 49 of the case, which the judge was entitled to find. Those were his findings on the evidence. And that's taken me slightly off the stride. I apologise for... so that,
Can I just detain you slightly further?
yes.
Is there any difference of substance between the two pleaded meanings of strangle or try to strangle and the dictionary definitions? I quite accept the pleading obviously introduces context, which the dictionary doesn't do. But apart from that, in terms of the actual meanings, is there any difference between the pleaded contentions and the two dictionary definitions?
That's an interesting question. I hadn't considered it one against
Well, the reason
other.
I'm asking, just so you know, is that if there isn't, and if the judge could have simply said, well, we've got two pleaded alternatives here, let's have a look at them and see which is the right one, could he have been criticised? And if he couldn't have been criticised, why does it matter that he chose it from a dictionary? But that depends upon whether there's any difference between the two.
Well, my answer to that would be that I don't accept the premise that the judge was just using the dictionary as the crutch definition. He used it as a check on his analysis, which was, well, why use the words try to? That was very much at the heart of his reasoning when deciding which of the two tiers of meaning that strangle could convey. But the essence of the analysis from the hypothetical reasonable reader's point of view is, when seen against the context of all the other matters of guns being removed from the house by the police, why use the word try to?
I understand the reasoning. Yeah.
So that's the reasoning. But
what would you say to the argument that a judge trying to come up with the single meaning based on what the reasonable reader would understand should not have resort to a dictionary except as verification? In other words, he should approach the question de novo, should reach a view and then, if he felt the need for verification, he could have resorted to the dictionary.
Well, one has to remember the timing. This was, the judge referred to the dictionary after he'd been sent a week before trial the note to the judge, in which my learned friend had put in evidence of what the CPS said.
Yeah, I'm really trying to get at what the general approach should be. Is it unreasonable to suggest that a judge taxed with the task of deciding what a reasonable reader would understand should approach that from, as you say, a matter of impression, and then, if necessary, verified by recourse to external sources?
Yeah, your Lord, I discern your Lordship's question to be directed to the order in which he does it. Does it matter whether it goes to the dictionary first and then proceed to analyse? It's difficult to answer in this case, of course, because the judge, the hair had been set running by the note that he was sent by the defendant. It may be that the judge would never have bothered to go to the dictionary as part of the opening argument or meaning had he not been
But it
sent.
may be that we will have to give some sort of general consideration to this question beyond the context of the facts of the appeal.
As to whether the judges should refer to...
In other words, should we say a judge shouldn't normally go to the dictionary at an early stage? He should decide what the reasonable reader would conclude, and then, if necessary, go to the dictionary.
Yes, well, to be fair to the judge, if one looks at the...
Well, I'm trying to move it from the context of this case.
Yes, the context of this case. I mean, I don't accept that the judge did that. My friend characterised it...
I think I've got it, but you don't accept it.
I don't accept. But yes, I mean, I think there would be, if he simply marched into court without prompting and just spouted dictionary definitions without reference to the words complained of, the criticism might be better founded. But as we've seen from the extract on page 163, I mean, his starting point was, well, you might want to look at these definitions because of the impact this has on tried to. But of course, what matters, as he says on page 163, is the context in which it was used in the message. So
I rather wonder whether it's appropriate to look at a dictionary at all if you're talking about ordinary words which are comprehensible by the ordinary person. I mean, I can see if you had a posting which was of, wit worthy of Oscar Wilde, using obscure vocabulary, or rather recondite vocabulary, indeed the word recondite, then you might need to, the ordinary reader might have to get out a dictionary to find out what on earth this meant. But if it's ordinary language, no ordinary reader would look it up in a dictionary.
yes, but of course, the artificiality of the exercise is the judge has to form the decision on meaning as a matter of impression. But because of the way trial by judge alone works, or determination of meaning works, he's bombarded with argument by counsel. If the had the judge's judgment said, I rest my finding on meaning on the dictionary definitions, the criticism might be rather stronger. But to castigate a judge because he responds to a plethora of inadmissible evidence, as we would have it from a litigant, on meaning, and then has a riposte, say, well, look at the dictionary definition in the course of argument, would seem a very harsh criticism to attack him for resorting to a dictionary when it was, in fact, one of the litigants who went down the road of introducing...
The litigants invites them to.
But it would be, I mean, as I say, as I conceded, you'll see from the transcript in the passage just above the one I cited on page 163. I mean, I said parties used to be jumpy about dictionary definitions in the days of juries because one didn't want to trespass on the rule that you don't adduce evidence in relation to meaning. So while you might have had dictionary definitions thrown around in front of a judge on a capability, meaning in the days of capability determinations rather, one wouldn't have typically had counsel addressing a jury on different dictionary definitions because that would be trespassing on their function. As you've seen from the examples we've given, it's now so well established as almost to be uncontroversial. You've seen examples from Mr. Justice Eady, and indeed an example we gave, I think, from the air raid wardens in World War II, which is a case that's gone out of my head. You'll bear with me. Perhaps if I can turn to the examples in the case. But it's been around, yes, the case, it's page 84 of the bundle, it's paragraph 23 of our case. This was a 1945 decision of Mr. Justice Croom Johnson, as he then was, in Cleghorn and Sadler. And that's the extract we've set out there about the words to pry. And you'll see there that Mr. Justice Croom Johnson referred to the smaller Oxford in dictionary definition of to pry as meaning to look, especially to look closely or curiously, to peer inquisitively or impertinently, to spy. So use of dictionaries in a meaning context has been around a long time. We say not as the ultimate yardstick to determine the issue, but as a form of judicial notice of a kind that is, we say, very common in other spheres.
Just testing it out,
yes.
In a modern day formulation, dictionaries might be thought to be slightly old-fashioned, and the internet would be one way in which people would look things up. That would produce a whole lot of completely different category of information. If you put the words into the search engine, would that be admissible?
Well, not for judicial notice purposes, because dictionaries have are regarded as a repository of, authoritative repository of meaning. I mean, it always tends to be, in this country at least, the OED or one version or other of the Oxford
We're not really
Dictionary.
looking for that, are we?
Well, no, only as a check. And if we're only arguing for the use of dictionary definitions as a check by way of judicial notice, which is the way it's traditionally been used, as indeed was apparent from that famous citation from the Baldwin case, which is at page 83 of the bundle. Those observations of Lords Reed and Denning in Baldwin. I'll just read them out because they're in front of me. Top of page 83, a judge is supposed to know the law, the English language, and such facts are as common knowledge. If he refers to authorities or dictionaries or other works dealing with these matters, he can safely do so because his general knowledge enables him to check and appreciate them. Now, whether a dictionary that has proper editors can be put on the same level as just unmediated content on the internet is debatable. And I think exception would be taken if it's simply just random definitions culled from the internet, because it's close to what my learned friend did in his note to the judge. He put in an example of a newspaper article where the phrase "try to strangle" was used. Well, that's irrelevant because that article has nothing to do with the context in this case. And to answer my lady's question, that would be the similar vice of just plucking random results from a search engine list of results for a particular word. I think a dictionary is accorded a special place worthy of judicial notice because it's perceived to be authoritative.
And I appreciate it's not this case, but how does the judge deal with online postings that include abbreviations like LOL or emojis, which you might not recognize?
Well, then you probably end up straying into the world, the borderline, the badlands of innuendo, which you've seen some examples given, like Judas. I mean, would anyone seriously expect the reference to Judas to be pleaded as an innuendo? The authorities say, well, everyone knows who Judas was. Just as in the Hong Kong case we refer to in the footnotes, reference to somebody as the Hong Kong bin Laden would not require an innuendo. So it's a question of degree in each case. I mean, I dare say, without being unduly ageist, that a judge might need a bit of hand-holding with some of the more esoteric terms used on social media, like LOL and some of the others. But we may be getting close to the point where some of those terms are now so ubiquitous that they don't require further elaboration. I mean, one recalls in relation to LOL,
Some are like them.
Yes, well, LOL is laugh out loud, but I think David Cameron, the former Prime Minister, thought it meant lots of love and would sign his emails to Rebecca Wade as LOL.
Whereas it means laugh out loud.
Laugh out loud, precisely. I think, but he mistakenly thought it meant...
Not all judges are completely unfamiliar with it. We do have grandchildren.
If you'll permit me for a moment to go back to the use of dictionary in the context of this case.
Yes.
Might it be said that it betrays a rather analytical approach by the judge, which the reasonable reader of this post would not observe, because it involves drawing a distinction in the mind of that reader between the use of he strangled me, which would have been, as I understand your submission, permissible, but he tried to strangle me would not be, because that would carry an imputation of some intent to murder.
Well, the answer to that, in my respectful submission, would be he went to the dictionary a week after he'd been sent a lot of submissions of evidence about how the words should be used in a technical, legal context.
But he didn't pay any attention to those, did he?
Well, he didn't, rightly, my submission, because it was inadmissible.
Well, it's slightly incongruous to justify his use of the dictionary because he received material which he didn't.
Well, his opening words were,
take
can I
into account.
well, what he was saying, perhaps the context is important, because when you look at the top of page 163, what he says is, can I suggest that both of you look at the Oxford English Dictionary definitions, trying to do something. One can't divorce the argument as it unfolded from what had actually taken place. So the judge was, having been provided with a plethora of lawyers' material to put about how what strangle means in the criminal law context, the judge tries to bring it back to earth and refocus the argument on the ordinary reader by going to the dictionary definitions. Again, there are further observations about if you look at page 164, at the bottom right-hand corner, there's an exchange between the judge at line 15 on internal page 16 of the transcript. Very well, I hear what you say about it, I'll do my best, but nobody should expect I have willing to pretend my understanding of how Facebook works, I don't. Mr. Price says it's certainly not a matter of judicial knowledge, one can assume. Then Mr. Price says, finding in relation to dictionaries, again, very briefly, one has to take into account the audience and the mode of communication. This is a ephemeral publication on Facebook. People aren't going to have the OED in front of them as they're looking through it on their screen, and that context is important. As I said, there's no need to deal with it in detail now, but my submissions it's not appropriate. I'm not trotting an argument on that. He says, I readily understand that both of you say beware dictionary definitions. I'm perfectly prepared to take that cautionary joint proposal on board, but you may find it difficult to dissuade me from paying some heed to it simply because it's an ordinary English word and it's defined in an authoritative English dictionary. So,
to what extent is it appropriate for us to look at this discussion in the course of argument in reaching an understanding of the judge's judgment?
Because the criticism is made of him as to he used, appears to be a criticism, he used a dictionary and used that as the sole crutch.
Is it appropriate to interpret his judgment by reference to argument that took place beforehand?
Well, I think in a meaning determination, the argument is not unimportant because the criticism is always made that the judge is over-elaborate in his reasoning. One has to know why he gave the reasoning he did by reference to the argument that took place before it. So we say it's not illegitimate to look at what unfolded in the argument before it because it explains why the dictionary definition came to be used. I'm just wondering whether there's any... I don't think there's anything I can usefully add on the dictionary's front. Well, perhaps I think for completeness, if I can ask your lordships and ladyship to look at page 176, there's another sequence of exchanges about... starting at bottom right-hand internal page 100 of the transcript, bottom right-hand corner on 176, line 18. I'm surprised to be, so this is on day 3, I'm surprised to be told I'm not allowed to look at a dictionary. I think those are relics of the days when juries tried cases. As your lordship knows, the landscape has completely changed and lots of rules that were there for good reason to avoid the jury having a trial of dictionaries at court. Judge says, I readily understand why you don't want me to look at dictionaries or consult works of references about sentences or paragraphs, but words, ordinary English words, they do have a rooted meaning. And then I don't want to read it all, because your lordships can read it at your leisure upon retirement. But perhaps just look at again at the judge's observations at line 14 onwards, at the top of page 177. You wouldn't, but actually it does have two meanings, and the context gives a hint as to which meaning is being used and which is intended to be understood. So again, at the end of the day, the acid test for the judge was the context in which the word was used in the publication, not, as my learned friend criticised him, using the OED as the crutch that provides the ultimate basis of his decision. So we say it's fair to characterise it as simply using it as a check in the context of the arguments that were being ventilated before him, starting with the criminal material that my learned friend put before him, before the oral argument had even begun, a week before trial. I think I've said all I need or propose to say about dictionaries and the extraneous evidence. So unless there are any other questions, I propose to move on to what I describe as the chimera of the publisher's intention. Now, you'll recall that what my learned friend, I don't think he dealt with it in his oral submissions, though it's in his case, he seeks to substitute the question, what do the words mean, with what did the defendant intend to convey? Now, if one looks at the appellant's case, at paragraphs 14 to 15, and starts at page 51 of the electric bundle. It's a tab E of the paper core volume. Some of the phraseology there used in paragraphs 14 and 15 conveys the subliminal message that this appellant was conveying a meaning that she hadn't intended, that was inadvertent. Look at paragraph 14, second line. For example, a defendant describes accurately and in good faith an act carried out by the claimant, but the claimant alleges that the words used impute to him a particular mental state and hence a criminal offence more serious than the act sought to be described by the defendant. And then in paragraph 15, further down, third line.
I've got a wrong page. Which page?
I'm so sorry, it's page 51 of the...
Thank you.
And just so you have it, it's paragraph 40.
I've got it.
40, I'm grateful. And then paragraph 15, we have, again, this sort of special pleading. Allegations involving domestic violence and sexual harassment are prone to give rise to such a dispute. The law of defamation may have reached such a level of artificiality that the victim of such an act can be liable in damages to her aggressor if she frames her truthful description of what happened in words that inadvertently give rise to an imputation as to a state of mind that she is unable to prove. But if so, it's all the more important to ensure that her words do in fact bear the inadvertent meaning to an ordinary reader. And then again, there's a reference to the surprising reference given that the intervention by Liberty was rejected by this court. But again, the last sentence, the aim is to prevent artificial, some may use a stronger word, outcomes arising in the future. And in paragraph 17, 17.1, the defamation defendant acquires no benefit from her intended meaning. Now, that is at the very least a subliminal message, to put it no higher, that this poor appellant was the hapless victim of having misspoken, and she's somehow in a special position by virtue of being the victim of domestic violence. We know from the facts of this case, which I'm not going to rehearse again, that the evidence shows that at the time of the incident, this victim of domestic abuse, at least, did not feel inhibited from telling the police that not only had the respondent attacked her in the way alleged, but that he actually said he was going to kill her as he set about gripping her throat. Now, that, we suggest, eloquently demonstrates why any speculation as to what the meaning was intended by the publisher is a Pandora's box which should remain firmly closed. It is quite wrong to invite the tribunal determining meaning to speculate as to what was intended by the publisher. It forms no part. It leads to greater abstraction and divorces the fact-finding tribunal from the real issue in the case, which is what the hypothetical reasonable reader would have determined the meaning to be. And in any event, we say, and despite the special pleading about the supposed plight of domestic abuse victims being exposed to the risk of defamation claims for inadvertently misspeaking about their experiences, there is in fact nothing new or controversial in the proposition that defendants need to pick their words carefully lest they convey a more serious meaning than they might have wished. And can I take your lordships to a famous, much quoted passage from the judgment of Lord Devlin in the Lewis case? That's at electronic bundle reference 547. The authorities in volume 1 of the authorities, tab 20. It's right, if you're using the paper version, it's right at the back, I think. And it's a passage that begins at the top of the page.
Which page are you on?
Electronic bundle, page 547.
Thank you.
It's Authorities Bundle 1, tab 20. It's the case of Lewis, House of Lords decision. Lewis, a very famous case of Lewis and the Daily Telegraph.
Yep.
And it's just the observations made by Lord Devlin at the top that make good the point about the need for care. It is not, therefore, correct to say, as a matter of law, that a statement of suspicion imputes guilt. It can be said as a matter of practice that it very often does so, because although suspicion of guilt is something very different from proof of guilt, it is the broad impression conveyed by the libel that has to be considered, and not the meaning of each word under analysis. Then this: a man who wants to talk at large about smoke may have to pick his words very carefully if he wants to exclude the suggestion that there is also a fire, but it can be done. One always gets back to the fundamental question: what is the meaning that the words convey to the ordinary man? You cannot make a rule about that. They can convey a meaning of suspicion, short of guilt, but loose talk about suspicion can very easily convey the impression that it is a suspicion that is well-founded. Paraphrasing that, if you want to talk about choking without suggesting there's been an attempt to kill by strangulation, one needs to be a little more careful. This is not lest we be moved by the appeal for a special rule for domestic abuse victims, terrible as that is to be a victim of domestic abuse. But they have to be careful. This was not a complaint being made to the police. This was statements being made to her ex-husband's new girlfriend on Facebook years after the event. And it's a comment that was made not once but twice. And the second time larded with references to police being removed from the house, guns and everything else. That is what the judge very much had in mind. Briefly in relation to the issue of context, and this is in answer to my Lord Kitchen's question. I've already taken the court, and I won't go again, to paragraph 40 of our case, where there are the bullet points summarising, that's page 92 of the electronic bundle, where the judge we summarise how the judge did indeed take account the context and circumstances of publication. And again, if one looks at the transcript, one can see that the judge very much had in mind the context in which the words were used. I have two brief passages I can take very shortly. If one goes to electronic bundle page 170, again, these are some exchanges between my learned friend, Mr. Price, and the judge. And at line 1 on internal page 22, so halfway down the left-hand side, I agree. This is the reference to the North London gangster allusion. I deliberately put it simply and provocatively because I wanted to tell you the impression it made on me. And so you can say, well, that's not right, and you've overreacted. So he's looking at the impression the exchanges as a whole made upon him. And then again, if one goes to page 177 of the bundle, which is a passage I think, I'm not sure if I've taken you to this already, it's page 177, it's at the top of the left-hand quadrant, halfway down at line 14. This is the dictionary definition. You wouldn't, but it actually does have two meanings, and the context gives a hint as to which meaning is being used, which is intended to be understood. Further down, you'll see the judge's reference, the Court of Appeal referred to, lines 19 to 21. I did get the impression, I thought it helpful to review the impression that it formed on me, and I did get the impression that I might be, not that I was, dealing with a North London gangster who'd made a success of business as well. I think I don't want to say any more, but it's just to say that there is simply nothing in the suggestion the judge didn't have regard either to the context in which the words were used, or indeed the impression the words made upon him. He was not slavishly following the dictionary definition. Finally, the justification point. Again, I hope I've dealt with, I don't want to take time with this, but my learned friend made observations which go way beyond the parameters of his appeal. You'll have heard him make comments, the judge downplayed this or that. There is, to be clear, no appeal from the judge's findings on the evidence. And my learned friend is stuck with the judge's findings on the evidence, and indeed his characterizations and evaluations of the evidence. Again, the views he expressed in the judgment on the alleged strangling incident are recorded in paragraph 43 of his judgment. That's at page 140 of the electronic bundle. And again, this has been quoted in both cases, but it's perhaps an idea to remind oneself what the judge found and did not find. And of course, you have in mind the evidence given by the appellant herself. He says he didn't accept, I don't accept, he says, that he, the respondent, merely put one hand over her mouth while he was standing on a stool or chair, that his hand would have been at his thigh level. He couldn't have exerted more than momentary pressure on her mouth from which he could instantly have escaped, nor could he have left the reddening marks on her neck or throat, which I'm satisfied were seen by the police. Now, what he's doing there is discounting the evidence given by the respondent. He says, I do not, however, believe that he threatened to kill her or did anything with his hands with that intention. I do not believe that he was capable, even in temper, of attempted murder. The most likely explanation about what happened is that he did in temper attempt to silence her forcibly by placing one hand on her mouth and the other on her upper neck and her chin to hold her head still. His intention was to silence, not to kill, but nothing about violent choking or gripping the neck. And this reflects the views he expressed during argument when one goes to the transcript at 168 in the electronic bundle. If I can ask your lordships to look at the lower right-hand quadrant, starting at line 19. I'm so sorry, it's page 168 of the bundle.
68.
This is day 3. So it's at the end of the trial where the judge is evaluating his argument about...
Internal page.
Yes, and it's internal page 12 of the transcript, right at the bottom.
Right.
Line 19, Mr. Justice Mitting says, what if the truth of the matter is he was trying to shut her up, not by killing her or by asphyxiating her, but by placing his hand over her mouth and keeping her head still by putting his other hand around the upper part of her neck. You can't shut somebody up just by putting a hand over the mouth. You would need to keep her head still. And then over the page, Mr. Price, you can shut somebody up by putting your hands around their neck if you strangle. He says, of course you can. That would be a far more dangerous thing to do. Most people think of the risk of strangulation is because of asphyxiation, suffocation. There's an obvious risk, but a further risk which brings people before the criminal courts charged with manslaughter rather than murder because they don't intend or expect death, which is a vagal inhibition. Mr. Price says, whatever it was a very serious act of domestic violence if my client's account is correct. Quite, but if the truth of the matter is that in temper, to shut her up, he put his hand over her mouth and held her head still by using his other hand under her chin, the top of her neck, to ensure that he stopped shouting at him, whatever it was. And that's an extremely unattractive piece of domestic violence and frightening for the victim, but it isn't quite the same as that which is implied by strangling. And then Mr. Price intervenes, saying there's a constriction that takes place and one has to have an element of reality here. This is a defamation claim. The claimant is asking for damage to his reputation in the context of a domestic dispute. The judge says, I know that, but I think anyone viewing these two factual possibilities, that he in temper tried to shut her up by placing his hand over her mouth and held her firmly by the neck to stop her head moving, and so releasing the constraint on her mouth, would regard that, I think, as of a different order of magnitude from someone who put his hands around her throat deliberately to constrict her breathing. Now that is reflecting what the findings ultimately recorded in paragraph 43 of the judgment. And what is perfectly clear is that the judge rejected the evidence given by the respondent of a violent gripping of the throat, putting her in fear of her life, that she thought this is it. He's made a finding, as he says, and I don't seek to excuse it in any way, an unattractive piece of domestic violence that was frightening for the victim, but it is of a different order of magnitude to what was pleaded, and indeed the meaning which my learned friend sought to justify, which, let us not forget, is in paragraph 14.1 of the defence, which is at page, electronic bundle page 205. This is the, to use the old terminology, as this is pre-2014 Act, the defence of justification. 14.1, meanings that the defendant alleges to be true. The claimant violently gripped the defendant's neck, which inhibited her breathing and put her in fear that he intended to kill her. And the short point we've made in the case is that even if the judge had found that lower meaning to be the one that the words bore, it wouldn't have assisted my learned friend on his plea of justification, because the judge's findings of fact were demonstrably of an act that fell well below anything revolving a violent gripping of the neck, an asphyxiation, to use the judge's phrase, that put her in fear that he intended to kill her. While we're there, you can see there the point about the freestanding, dangerous and disreputable movement, meaning that's pleaded at 14.8. And if one looks at 14.9, the facts on which the defendant relies, on or about 23rd of March, in the course of an argument, the claimant attacked the defendant and at one point had his weight on top of her and his hands gripped tightly round her throat. She was unable to breathe and was frightened that the claimant intended to kill her. That was the evidential basis for my learned friend's plea of justification. The judge rejected it. The plea of justification would have failed even if the judge had picked my learned friend's meaning in preference to the one pleaded by the claimant.
The judge did find, didn't he, that there were reddening marks on the neck or throat?
But not because there'd been any gripping.
How do we know?
Well, because the judge says he put one hand on her mouth,
Yes.
and one on her neck, under her chin. Now, you can't strangle somebody when one hand is on the mouth and one hand is on the neck. It's unattractive, but it's not a strangling.
It can't be strangling because?
Well, one hand is on the mouth,
Yes.
one hand is on the neck.
Yes.
That's not an asphyxiation. The judge is not making a finding there's been an asphyxiation. He's saying that it's been I think one other place he talks about an assault, but it's not a violent.
Well, he's made a finding that wasn't
Yes.
the intention. I can see that. But the actual thing which happened,
Yes.
you're saying that can't be.
Well, it's not what was being justified. It wasn't a violent gripping of the neck so as to put the defendant in that she couldn't breathe and was in fear of her life. That's not what he found.
The mechanism that you've just demonstrated, which reflects, you say, the finding of the judge, was that on the basis of the evidence given by the defendant as to what he...
By both of them.
Sorry?
It was on the basis of the evidence given by the defendant and the claimant. The claimant gave his evidence.
Sorry, the claimant, yes.
Yes, and so did the defendant.
So
And the
that's how he described the mechanism of injury, is it?
Yes, that's from the judgment.
Well, the judge's finding was somewhere in between the two, wasn't it?
Yes, well, in terms of the claimant.
As it's perfectly entitled to.
Yes, it's apparent from the opening of paragraph 43. The claimant was simply saying, well, I just put my hand on her mouth to shut her up. And the judge, well, I'm not accepting that. It was anything as innocent as that. He put his one hand on her mouth and just to keep her quiet, to make sure that his hand stayed on her mouth. But, he does say it's a different order of magnitude between that incident and the one that actually happened. Again, I'm not defending it as attractive, but it is qualitatively different. And whether that would, again, degrees of magnitude are important when considering where something is an act which is an assault, and as the judge says, an unattractive domestic incident of domestic abuse, but not one that is of the order that was being justified by the defendant as one that was putting the defendant in fear of her life because of the
assaulting somebody is not as bad as trying to kill them, but it's
No.
still a serious and unattractive matter.
I wouldn't resign from that for a second, and I don't seek to. And indeed, the judge's characterisation from it as unattractive is.
But I mean, your point is that it's not as serious as not trying to kill them, but doing what it was pleaded the words meant.
Yes, but even on, I think the soundbite from the point I'm making is that even on the case the defendant was seeking to make, the evidence fell short. The judge did not accept that the full weight of the claimant was on top of the defendant. He did not accept that his hands were violently gripped around her throat to the point she couldn't breathe and thought she was going to die. Nor did he accept the evidence that she gave at trial, which I've not gone to and I don't wish to, but you have the references in the case, that she'd simply forgot to say, as she did to the police back in 2003, that the defendant was saying, the claimant was saying, I'm going to kill you as he was doing it. And you'd thought that was a pretty material piece of evidence to
I'm really not sure this is your best point.
No, well,
if you grip somebody hard enough that it'll be visible marks 2 hours later, that's pretty serious.
Well, as I say, I'm not belittling it. I'm just saying, but the judge was entitled to say it's of a different order of magnitude to what the defendant sought to prove. Whether that would sound in damage saying, well, it's unattractive.
I was going to ask, I mean, if you prove a defamatory statement and the defendant proves justification, as it were, for 90% of its gravity, but it just misses the target of justifying the statement as a whole, do you get damages for the 10% or the 100%?
Depends. I mean, there are a range of, so I have to give an impromptu tutorial at least. There is something called, there's a case called Pamplin against Express newspapers, where if what the defendant proves falls short of the actual sting, but nonetheless is damaging, I think it was Lord Justice Neal in that case said the damages can disappear, sometimes even to vanishing point, I think is the phrase that's used. But in certain cases, depending on the mismatch between what's proved and what's the damages can be significantly reduced. And here, there's no question of the claimant receiving damages on the basis that he was a man who did nothing that was blameworthy or that was worthy of condemnation in terms of the assault on his wife. That would have been weighed in the pot.
I beg your pardon.
Sorry.
The judge's finding that the sting of the postings was that the claimant was a dangerous man.
Yes.
Was reached on the basis of all of his findings, including his finding in relation to the strangling.
Yes, if one looks at, because you've got his characterisations of the other incidents.
Yes.
I hope it's the quickest, given the time, I hope the quickest way to summarise it is to look at the summary we've given in the case. If you'll bear with me, I will turn up. Yes, it's at on the electronic bundle. It's starting at page. Perhaps the best place to start is page 96. I don't think I need to take too long on page. Yes, page 96 of the electronic. This is our case, and it's a summary of why we say that the evidence would have fallen short. Paragraph 48 deals with the matters we've just dealt with, which is the strangling incident. So I'm not going to repeat all that, but paragraph 49, we say the evidence fell woefully short of even the lower defamatory meaning which the appellant sought to justify in relation to the supposed strangling attack. The defence of justification would plainly have failed in any event. In the words of Lady Justice Sharp, it's true that the judge, she says at paragraph 25, it's true that the judge found as a fact that during the course of an argument the respondent had committed common assault at least by placing his hand over the appellant's mouth and putting his hand under her chin to stop her speaking. However, there's a material difference in gravity between such conduct, however unpleasant, and an attempt to kill by strangulation. And then really what I was going to come to were the other elements.
I think
the threats issue and the...
If I might just stop you for a moment.
Yes.
The reason for my question was this, that if the judge's finding about the sting is based upon, among other things, his finding that the import of the post was that there was an attempt to kill by strangulation, were we to come to the conclusion that the post does not mean that there was an attempt to kill by strangulation, to what extent would that lead to an unravelling of the judge's finding about the sting?
Well, it wouldn't. It depends what the meaning you found. We would say if my learned friend is only contending for the meaning that he was. My learned friend's case is the judge should have found the meaning for which we contended in the defence.
Yeah.
Now, we'd say the judge's finding in relation to that falls below what was being put forward, and therefore, even on the defendant's case, the sting includes dangerousness. We know that because the defendant himself pleaded in paragraph 48 of the defence the dangerousness meaning is a sweep-up overall meaning to be drawn from the underlying inferences. So even on his own pleaded case, even in relation to the meaning he would have the judge find, dangerousness was always going to be in the pot. And the difficulty he's got is threefold. Firstly, the judge's findings as to the difference in magnitude between what happened in March 2003 and what the defendant was alleging. And then if I can sweep up in relation to the other two issues, just as paragraph 51.1 of our case on page 97, with respect to the threats issue, the judge was not satisfied that the respondent had made any threats of immediate violence. With respect to the Tring Market incident, that's the breach of the non-molestation order, the judge found that while the respondent had breached the order by virtue of discussing matters with the appellant other than about her son, he considered the breach to have been comparatively trivial and one which had been neither premeditated nor the subject of any immediate complaint or action by the A. Now, they were not entitled to go behind the evidence to decide, well, what did the judge have in mind? What was he referring to in relation to the fact there was no immediate complaint or action? Those are the judge's characterizations of the evidence, having heard it. And my learned friend cannot, on this appeal, seek to go behind the judge's evaluations of the evidence or his characterizations as to where it gets him on dangerousness. The judge took the view that the breach of the order was trivial, comparatively trivial, and the threats issue he just did not accept, was not satisfied that there had been any immediate threats of violence.
Did the judge make an explicit finding on the question of dangerousness?
Well, not as an issue of fact. In relation to meaning, he certainly did. He took the view that the words...
He didn't have to.
Didn't have to, because he said take it in the round.
Yes, quite.
He said they don't come close to show that he was dangerous.
But if we're now in the debate about whether justification has been established,
Yes.
Surely we've got to address the question whether, given the judge's findings, the allegation of dangerousness is made out. If the judge hasn't made any explicit finding in relation to that,
Well,
how do we set about resolving the
well,
question?
I think it's right to say he made no finding, because he makes a finding that the justification, I have to find the actual passage. Yes, it's paragraph 54, on page 143 of the electronic bundle. He says this: the defendant has proved some justification for the words which he used in the Facebook postings. The claimant did commit an offence against on the 23rd of March, at least common assault. He was arrested 3 times, there were gun issues. He made threats, though not of immediate violence, against her. But she has not met the sting of the postings that the claimant was a dangerous man. The impression given by the postings to the Order reader was a significant and distorting overstatement of what in fact occurred. And what in fact occurred include his findings, not just in relation to the supposed strangling incident, but in relation to the comparative triviality of the breach of the order and the fact, his finding that there were no threats of immediate violence against her. So he's made a qualitative evaluation of the evidence that he says falls short of meeting the sting of dangerousness. And I cannot emphasize enough, perhaps to the point of tedium and repeating myself, that was the very sting which the defendant was herself seeking to justify, and that even on her own meaning. So even to answer my Lord Kitchen's point, that even if this court were minded to change or uphold the defendant's meaning, the defence of justification would still have failed because of his findings of fact and his characterizations of fact, and his conclusions as to whether they made good the sting of dangerousness. The sting of dangerousness was there on either meaning, the claimants or the defendants. Your Lordship's Ladyship will bear with me a second. Pleased to report that I may have come in under time and under budget. So unless there are any further questions, I'll just consult with those instructing me in case there's some. Unless I can assist further, and I think my learned friend may have the benefit of some extra time.
Thank you very much, Mr. Barker. Ms. Overman, do you follow? No, I'm afraid I omitted to ask Mr. Jonathan Price earlier today if he did. Yes, Mr. Price.
There's a number of factual errors that I need to correct, but can I go straight to the point of principle in relation to the appropriate standard of appellate review? I think the formulation that was put in oral submissions that we didn't find in the respondent's case was an acceptance. I think that the appellate court can look at the article and form its own view as to meaning, which is the start point. Then...
Can or should?
Well, must, yes. I mean, I'm saying what I think it was put by my Lord Kerr to learned friend, and I think he accepted that. My submission, obviously, is that the court must do so and starts off with that. Obviously, if the happy position is reached where the appellate court agrees with the trial judge as to the correct meaning, we don't have to go any further, but the crux of this is what happens if the appellate court takes a different view to the judge, and the test that was formulated, I think, was if the judge's meaning was within a reasonable range of meanings open to him, then the appellate court can't substitute its view as to the right meaning, and that essentially is a capability test. Which would be a very low threshold, and it's actually far lower than the threshold in any of the cases that were cited to the court, and it's lower than Proposition A in Bukowski. It's effectively a capability test. And I'm not going to go over all the policy reasons why it shouldn't be set that low.
I had understood that you were prepared to go along with the formulation of Bukowski. That's at paragraph 39.
Well, yes, I mean, I think...
And I thought the respondent was as well.
Well, I suppose that putting the matter with exact precision, which I probably haven't done before, is this. I stand by what is said in the respondent's case as to the correct legal test, which is the appellate court looks at the article from the standpoint of the reasonable reader, forms a view as to its meaning, and if that meaning is materially different from the trial judge, it substitutes that meaning. I put it in the context of a defendant who's arguing for a lesser meaning, because that is facts of this case, and because that has Article 10 implications if you allow the higher meaning to go forward, notwithstanding that you as the appellate court don't think it's the right meaning. And if we're going to have a single meaning rule, then the court's got to get to the right meaning. And if the Court of Appeal, whether it's 2 or 3, take a different view, it's probably better when there's 5. If 5 take a different view, then that would perhaps be a reliable indication that the judge hasn't got the right meaning. We happen to have 5 because my client's been given permission to appeal in this case. And one of the issues before the court in the agreed statement of facts and issues is whether the trial judge's meaning was the correct meaning. But I stand by that relatively low threshold for appellate intervention, certainly in relation to a defendant. In terms of a claimant, there's always the danger of over-elaborate analysis, a legal analysis, which tends to favour a claimant. So the artificiality of the process generally favours the claimant rather than the defendant, because things look far more serious when you start analysing them in the way that a lawyer might analyse them. But of course, I have to accept the logic of my position would be that if the Court of Appeal took the view that the claimant's meaning was materially more serious and that was the meaning of the article, perhaps with a pause for thought to say, am I being too much of a lawyer about this? Because that's an injunction in the Jane's Principles, then it would have to be overturned. But if I have to go back to Bukowski, then on the facts of this case, this would have, A, required the Court of Appeal to ask itself what it would have done if it was the trial judge, which Lady Justice Sharp, with respect, said that's not what she had to do. And given that permission to appeal has been granted by this court, and therefore this court's decision on the single meaning becomes the authoritative one in the same way as in the, I think it was a contract case referred to by Lord Neuberger in the Oriental case, and that was about whether a notice took place on a particular day or the day after, and I think 3 of the court, I think it was the Supreme Court, or maybe, I think it was the House of Lords actually, 3 members felt it was one day and 2 felt it was another day. Therefore, as a matter of law, it took place on the day when the 3 held that it should take place. So where we are now, permission to appeal having been granted, if the independent determination of 3 of you, or hopefully more, is that my client's case or meaning is correct, then it should be substituted for the judges on the basis of Bukowski. But even if I have to go further than that, I have to identify an error of principle in the approach of the judge. I can identify one, at least one, in this case. And to take the words of Lord Justice McComb in the Waterson case, it's the technique of a lawyer. It ties in with the over-elaborate analysis, which is going to the dictionary clearly not as a cross-check, going to the dictionary as the basis of your reasoning. And then I would add, although I don't have to, refusing to even engage with at least equally authoritative sources relating to the words in issue or very closely related words. Not taking account of context, because the reasoning that one sees in the judgment applies in all contexts. And I think insofar as it's appropriate to take into account oral submissions, and in my submission there's a great danger in doing so, one has to look at what's in the judgment. The context that he was talking about was the use of the word tried to. Just on the facts here, the note to the judge was put in along with other submissions prior to trial. There was no suggestion that he even looked at it. He didn't raise it at all. He just came out of the blue with about the point that he made about the dictionaries. He was then told by my learned friend, there's a caution, we shouldn't be using them. And then he puts that in his judgment as the sole basis, essentially, for his reasoning. It wasn't a check. I would submit it's wrong in principle even to go outside his judgment. But this idea that it was me that set the hair running is a complete red herring. He didn't engage at all with my submissions on context. And just while we're on this point, where the court, my learned friend and the Court of Appeal looked to the transcripts and the points about the North London gangster, what the judge said in his judgment in that paragraph, the sole paragraph on meaning, was that his construction of try to strangle, based on the OED dictionary, would have informed the ordinary reader about the meaning of the remaining comments. So it was his idea that try to strangle meant try to kill, which cast the other comments in a different light, which reflects the way in which they appeared in the exchange. It wasn't the other words making him think that tried to strangle meant tried to kill. And on the basis, in my submission, that this is a rehearing, to suggest that the impression was that the respondent was a North London gangster seems to demonstrate a fundamental misunderstanding about the nature of domestic abuse and the type of men who may engage in it, consistent with the downplaying of the factual findings of fact that he made, which fortuitously for the defendant, because she didn't say anything more than the fact of the breach and the fact of the threats, really, I have to say, demonstrates a fundamental misunderstanding. Actually, while I'm on this point, having reflected on the observation by my Lady Black as to the use of the word bias, in my submission, what's happening here is it's distancing the appellant even further from making an imputation about his mental state. She's just describing something that happened to her. I say that's implicit in the process. But she's doing no more than describing it as she saw it. And that's the relevance of that word. So, if I have to prove an error of principle, I respectfully submit that I have done so. If I simply have to satisfy the Bukowski test, then that must require this court to formulate its own view as to the right meaning. And if it's necessary to show an error on the part of the Court of Appeal, it's that they didn't even go down the first step of identifying the finding that they would have made if they had been the trial judge, and describing the hearing as not a rehearing. It must be a rehearing, must be open to raise the same arguments that you raised below, certainly if you've been given permission to appeal. In this case, permission to appeal was given by Lady Justice Arden, who was on the Camish case. I didn't take you to the Camish case, but it's one of the cases on the standard of appellate review. It's cited in Waterstone, so she was well aware of the restrictions on a appellate on a first instance determination of meaning. Nevertheless, she did give permission to appeal. The fact that she gave it meant the Court of Appeal had to engage with the process. The Court of Appeal was also wrong to describe the use of dictionaries as a cross-check. It clearly wasn't.
Well, in fairness, I think what Lady Justice Sharp says in the judgment is along the lines that it was a check as the judge said, something like that, and that the judge himself talks about confirming the meaning of the word strangle.
But his judgment is solely based on that reasoning, and this doesn't seem to be, in my submission, the passages from the transcript rather seem to support.
I wasn't referring to the transcript. In the judgment, he talks about using the dictionary to confirm the meaning.
In the judgment?
Yeah.
Oh, even the Court of Appeal judgment?
No, the judge's judgment.
Oh, no. Sure he said that, but...
Yes, it's paragraph 36. Of course, he just cited Rufus, in which he was a member of the court. He says, I don't understand that approach to prohibit reference to an authoritative English dictionary to confirm the meaning in ordinary usage of a single English word.
But with respect to him, he wasn't just confirming the meaning. He was saying, here's two different meanings, and then taking his reasoning from that. I mean, you don't need a dictionary to confirm the meaning. But my primary submission is it's not necessary for me to show an error in the approach of the Court of Appeal because I have been given permission to appeal. And therefore, in a system of law that applies a single right meaning, and an issue in the statement of facts and issues before the court as to whether the judge did arrive at the right meaning, that requires this court to make an independent determination, whatever it says about standard of appellate review in the future. One should not let this meaning pass by if the majority of you think it's the wrong meaning. Sorry, there's a miss. I don't think I'm going to go back to these points, deal with the points about the hands around the neck. I mean, if there's anything in it, you need to read the cross-examination of the of the defendant by Mr. Barker and what she said in that, and the judge's finding, accepting, as it was put to him in submissions, it's a serious act of domestic abuse. The minute he's got his hand around her neck with such force as to create red marks, she's not going to be able to breathe, and as he accepts, it's going to be terribly frightening for her.
Examination.
Yes. Yes. I mean, the case put to her was that she'd invented it all as a result of postnatal depression. The whole incident had been invented. And it was she was in tears throughout it. It was a very brutal cross-examination based on a lie, because the claimant's case was he just brushed his hand against her mouth. And I put it to him in cross-examination, would you accept that if you put your hand around the respondent's neck with such force as to leave reddening 2 hours later, that it would be acceptable to describe you as a dangerous man? And he said yes. His case was he didn't do it. And quite clearly it is appropriate. And the perpetrator of such a serious act of domestic violence should not be allowed to come to court and ask for damages and costs against the victim of such an assault on the basis, well, I don't quite know what basis, because what she said was entirely true on the correct meaning of trying to strangle. Her breathing was constricted, her throat was violently gripped. But in any event, I stress that my case on justification depends on an acceptance that the meaning needs to come down. The passage from the judgment of Lady Justice Sharp, on which my learned friend relied on to defend the rejection of the justification defence, was clearly based on the judge's meaning of attempt to kill. That's what she was saying. There was a sufficient difference between an intention to kill and what the judge had found. Not sure there's anything more, but I just want to check I haven't missed anything. I mean, it's all in the case anyway, if I have. So unless the court has anything further for me, those are my submissions.
Thank you very much, Mr. Price.
If I can bank some of the time as in my credit account, just to make one correction of fact that will take 2 minutes. My friend gave the impression, I'm sure inadvertently, that the judge was simply not addressed at during the argument, the oral arguments, meaning his evidence in relation to the criminal. That's not right. If one goes to the bundle at 167, one can, and I'm not going to deal with it in detail, but you can see that at internal page 6 of the transcript on day 3, my learned friend made the observation at line 2 of internal page 6, but if I may deal with it first as a matter of logic, since your Lordship has referred to the dictionary definition, which on one view is inadmissible, I would like to refer your Lordship to a statutory crime of attempted strangling with intent to kill. My learned friend then went on to deal with the OAPA, and then he was rather hoist on his own petard, you'll see on page 8 of the internal transcript at line 13, because while he was reading out the 1962 authority of Grimwood, the judge observed, interestingly, the facts in the law report cite, he thereupon took certain action which resulted in her being nearly strangled. That means nearly killed by exertion of pressure on the neck. So there's a bit of an own goal there. But it shows that it's not right to say that the judge didn't engage with my learned friend's argument. And indeed, his rather dismissive conclusion after all that on page 9 of the internal transcript on page 168, at line 22, he said, it shows the English language is an imprecise thing and one shouldn't get too bothered about precise meanings. So again, we say that reinforces the fact the judge wasn't slavishly following the dictionary definition. It was just something weighed in the pot to confirm, as he says in the judgment, his impression of the meaning. I'm grateful for the brief indulgence.
Anything arising from that, Mr. Price?
Well, I do stand by the point that this reference to the Oxford English Dictionary came out of the blue from the judge, and he repeated it in the closing submissions, and that was the only time he really engaged with my points, it having been raised by me.
Thank you. Well, cases on defamation don't very often reach this court, and this one raises a point of importance. We'll take time now to consider our decision.